I'm Robert Guest, and this is
Candice Hughes.
And today we're going to talk about what happens if you die without a will. Candice, if someone doesn't have a will and they die, what happens next?
It's not the end of the world, but it is a complicated process, and this is why I say everyone needs a will. If someone dies without a will, it's called being intestate. So you die intestate. You have no will. There's nothing to say. There's nothing to file with the court to say what needs to be done with the property, and so it's a longer process when we do it. And it costs a bit more to do that than if there was a will to probate with. But it can be done. It's just not the favorable way to do things.
Now, in our earlier video, which everyone has seen, you recommended that everyone gets a will. And one of the reasons was you said if you have a will, you can get your property and your finances, your heirs can get access to them quicker. Mm-hmm. Because if you have to go through the probate process intestate, you said it takes longer.
It does.
And let's start with this. If someone dies intestate, who are their heirs? Who's going to have claims to their estate? How do you determine who gets what? Where do you start?
Okay, so Texas has what's called the laws of intestacy, and that's when you have to identify the heirs that are able to take under the estate. And so the court goes through, and there's three classes that qualify. You have to be alive, obviously, at the time that your loved one dies to be able to take, or in gestation. This is some case law that goes in with this. You must survive the loved one by 120 hours. So this comes into play, let's say husband and wife are in a car wreck. Wife survives husband by 125 hours. Well, then she was allowed to take everything first, and then it goes to her heirs. So, and it gets a little bit more complicated, but it's called the 120-hour rule. And then you must fall within the class of heirs that are defined by the intestacy laws. These are defined in the estates code, but it's children, adoptive children, half-bloods is what they're called in there as well. Sometimes parents of the loved one.
I made a list. Do you want to hear my list?
You did make a list?
I made a list
Let's
for this
listen to
video.
that.
Tell me if this sounds right. The heirs are going to be your surviving spouse, biological children, their descendants, adopted children, biological parents, adoptive parents, siblings, grandparents, blood relatives, and then what they call collateral relatives, aunts, uncles, and nieces.
That's a good list, Robert.
Thanks. I like to be ready to go. Now, who cannot be heirs? If you die intestate, who is not an heir to the estate?
So if you abandon your child, take them to the fire department, whatever, you abandon them, you can't take anything from their estate. It's not allowed under the code. This is before or after birth. So if a father just abandons a pregnant woman, he can't take anything from that child if that child is to pass away later on. Any parent that commits a crime against a child or a loved one is not able to take from that loved one that passes away. This is also in the estates code. And if you cause a death to a loved one, if you go and kill your mom or dad, you're not going to be able to take anything from their estate.
Now, earlier when you said everybody needs a will, and if you have, let's say, a parent who doesn't have one, or you and your spouse doesn't have one, what do they need to do? Should they just call you and have a will planning meeting, or how do you get someone motivated to get a will and explain to them how much more complicated it is to die intestate?
So the good thing is here at Guest and Gray we offer free consultations, and so you can call the office and speak with one of the assistants. We can meet in office, we can meet over the phone. A lot of people, when it's cold out, they'd rather just talk about it over the phone. You don't even have to come in at all. At that point you would come in at the will signing ceremony, because I know the weather's changing. And so we can talk about it over the phone. We can send you all the information through email. Payment can be done through email. Then you only have to come in once to sign everything.
So the good news is, even though you're going to die, you can meet with Candice for free, so you shouldn't die intestate. If you need a consultation for a will, or if you need to know what your options are if someone dies without a will, call Guest and Gray. We have free consultations. Come meet with Candice. She will solve all of your problems. Thanks for watching our video. At Guest and Gray, we offer free consultations for criminal defense, probate, and family law. If there's a topic you want us to talk about, put it down in the comments below, and don't forget to like and subscribe.